Welcome to this explainer. Today, we're diving into a fascinating and incredibly relevant area of law: how exactly the state handles group-based threats against public order. We're going to explore the Partiya Nyaya Sanhita, the BNS of 2023, and break down how the law views collective behavior. I mean, when does a simple gathering cross that invisible line into a criminal threat? And how does the legal system differentiate between, say, a random street brawl and a genuine threat to national security? Today, we're going to map out exactly how the law categorizes these offenses, from a squabble on a street corner all the way up to a national crisis. So here's our roadmap for today. 1. Protecting public tranquility. 2. Unlawful assembly explained. 3. Riots and public affrays. 4. Promoting enmity among groups. And 5. Safeguarding national integration. You can really think of this agenda as a spectrum of escalation. We're basically going to climb a ladder, starting from the baseline foundation of keeping the peace, stepping up to localized street fights, escalating to organized riots, and going all the way up to severe macro-level threats against the nation itself. All right, Section 1, Protecting Public Tranquility, the Foundation of Peace. Let's establish right up front why the law treats group behavior with such intense scrutiny. It really all boils down to this one core principle: collective unlawful conduct is inherently way more dangerous than individual acts. You might be wondering, why does the BNS care so much about crowds? Well, because group behavior has a massive psychological element to it. It can rapidly escalate into total disorder, destruction of property, and even loss of life. So the BNS is designed to step in early. It wants to protect public peace, secure people and their property, and maintain the authority of the law way before a crowd literally turns into a catastrophe. Moving on to Section 2, Unlawful Assembly Explained, the Gathering. Let's step up to our first level of escalation and see how a simple, everyday gathering transforms into a recognized legal threat. Under Section 189 of the BNS, unlawful assembly is, at its absolute most basic, a group gathering with a shared unlawful purpose. But what's absolutely crucial to grasp here is the threshold for liability. You become legally liable simply by knowingly joining or just continuing to participate in this assembly while being completely aware of its unlawful object. You don't necessarily have to be the one throwing a stone, right? Just knowingly being part of the group with that shared unlawful goal triggers your liability under this specific section. And here is the magic number for Section 189, 5. To legally constitute an unlawful assembly, you've got to have a minimum of 5 persons. It's kind of like the worst impromptu group project ever. The law is super strict about this technicality. If the group disperses, or say members leave and the number suddenly falls below 5, well, then the specific offense of unlawful assembly legally cannot continue. The math is literally just as important as the intent. But look, obviously a group of 5 people hanging out isn't inherently illegal. It only becomes unlawful when they share one of 5 very specific common objects. Those are using criminal force to overawe the government, resisting the execution of the law, committing an offense, taking possession of property by force, or compelling someone to do an illegal act through intimidation. And here's a totally fascinating detail. This common object doesn't even need to be pre-planned. It can develop entirely out of nowhere, right on the spot, among the 5 or more people gathered. It's really interesting to compare common intention and common object here. You see, common intention usually requires a prior meeting of the minds, like a pre-planned plot, and that can apply to smaller groups. But a common object under Section 189, that only requires a mere shared objective in the moment, specifically among 5 or more people. Landmark Supreme Court cases like Mazalti v. State of UP and Lalji v. State of UP were absolutely crucial in explaining these exact nuances. They really solidified this whole idea of collective responsibility to discourage violent group dynamics. Let's hit Section 3, Riots and Public Affrays, the eruption. We are stepping up the escalation ladder again. We've talked about the gathering and the intent, so now let's see what happens when that mere intent erupts into actual physical violence. This brings us directly to Section 191, Rioting. Rioting happens when force or violence is used by any member of an unlawful assembly in prosecution of a common object. Pay close attention to that phrasing, any member. As highlighted in cases like State of Karnataka v. Kampaya, even a slight use of force turns the entire assembly into a riot. And get this, every single member of that assembly can be held liable for the rioting because that violence was committed in pursuit of their shared common object. So, the crucial takeaway is simple. Unlawful assembly is the mere gathering. Rioting is the actual use of force. To put it another way, unlawful assembly is the spark, but rioting is the full-blown fire. You literally cannot have a riot under Section 191 without first having an unlawful assembly. The violence is simply the aggravating factor that upgrades the entire crime. Now, let's shift gears for just a second to a slightly different kind of violence. Section 194, a fray. Unlike a riot, an affray is very specifically defined as fighting in a public place that disturbs public peace. It's not about some grand, organized, common object. As explored in the Jagannath Shah v. State of West Bengal case, an affray is about sudden, localized street violence. It's a personal quarrel that spills over and completely messes up the daily commuter's day, disrupting the civic order of our shared public spaces. And the contrast here is brilliant. For an affray, that magic number we talked about, it drops all the way down to just 2. It only takes 2 people trading blows in a public space to trigger Section 194. A mere verbal argument isn't enough. Actual fighting has to happen. But it sure doesn't require a large crowd. So if we compare them head-to-head, a fray is sudden, public fighting involving 2 or more people, and it's highly localized. Rioting, on the other hand, requires an unlawful assembly of 5 or more. It's driven by a common object, and it results in organized collective violence. One is a sudden personal disturbance, the other is a massive collective threat to the authority of the state. Okay, Section 4, promoting enmity among groups, the systemic threat. We are now zooming way out from physical street violence to the macro-level ideological threats that actually fracture a society. Section 196 of the BNS deals with promoting enmity. This section criminalizes intentional acts that encourage hostility, hatred, or ill will between different groups based on religion, race, language, caste, or region. India is, as we know, a deeply diverse nation, and as the Supreme Court discussed in Pravasi Balai Sangatan v. Union of India, disturbing harmony among these communities is a direct threat to the secular and fraternal values of the nation. It's not just about stopping a fistfight today, it's about preventing the deep-seated hatred that causes the riots of tomorrow. So how is this enmity actually weaponized? Well, the battleground for this offense is rarely physical at first. It's almost always verbal and digital. We're talking about hate speeches, printed publications, provocative public slogans, and increasingly toxic social media content. A single malicious post online can totally trigger Section 196 if it intentionally threatens the communal harmony of the country.
Which brings us to Section 5, safeguarding national integration, macro-level threats. Let's reach the absolute peak of our escalation spectrum. We started with street fights, and now we're looking at the most severe threats to the nation's core fabric and sovereignty.
Section 197 of the BNS criminalizes assertions or imputations that prejudice national integration. This is it, the highest level of threat. This section targets anti-national hostility, divisive propaganda, and statements that actively encourage separatism or just fundamentally undermine the fraternity among citizens. It is specifically designed to protect the very sovereignty, integrity, and stability of the entire country from breaking apart. How does the law determine when someone crosses this massive line? Well, it looks for 3 very specific steps. Step 1, the person makes spoken, written, or electronically communicated assertions. Step 2, the content of those statements absolutely must directly threaten the unity, fraternity, or integrity of the nation. And, crucially, Step 3, there has to be a clear intent, or at least a super strong likelihood of harmful consequences. Landmark cases like Kedarnath Singh and Balwant Singh have deeply examined these steps, ensuring the law targets actual, real-world threats to national integration, rather than just shutting down unpopular opinions. To truly understand why the Bharatiya Nyaya Sanhita includes these strict legal codes, we really just have to look at the Constitution. Values like unity and diversity, fraternity, sovereignty, and integrity of India, they aren't just empty phrases, right? They are the beautiful constitutional values that these specific criminal laws are designed to fiercely protect. The law restricts harmful speech and violent assemblies specifically to safeguard these core ideals. Which brings us to our final thought, and a massive question I want to leave you with today. As we've seen, the state has some incredibly powerful tools to suppress unlawful assemblies, riots, and hate speech. But under Article 19(1)(a) of the Constitution, citizens have a fundamental right to freedom of speech and expression. So how do we as a society perfectly balance the absolute necessity of public order and national integrity with the vital freedom to speak our minds? It is a serious tightrope walk, And understanding the BNS is definitely the first step in figuring out where exactly that line is drawn. Thanks for joining me on this explainer, and I highly encourage you to keep exploring this fascinating legal balance.